Welcome to our Wednesday webinar. Birkett Long is offering a series of fortnightly webinars on a range of different topics for individuals, families and businesses. I am Francesca Cousins and I am Associate at Birkett Long and I am a specialist in family law. So this week we are looking at ways to avoid the delays that are currently being faced by the family court. I will take questions at the end, so please do make use of our question and answer facility. So please, can you change the slide? So, of course, everybody would expect this slide at the beginning of a lawyer's presentation. Obviously, this is not legal advice. This is just for information purposes. At the end of the presentation, you'll get my contact details. As a team, we offer a 15-minute free consultation over the telephone to see how we can help you. So if you do have any questions that you don't want to raise on the question and answer and would like to speak to me personally, then just drop me an email or give me a call when you get my contact details. Next slide, please. So what are we going to talk about today? We are going to be talking about the current position and the problems that are currently being faced by the family court. We're also going to be exploring the other options that are available to families who are going through a separation. Specifically, we are going to talk about collaborative law, mediation, arbitration, private FDRs, which stands for financial dispute resolution, and I'll discuss that further later on. Then we'll have a summary and then I will open to questions. Please be kind with the questions. Next slide, please. So, are the delays in the family court just due to the pandemic? I would love to say yes, but sadly no. The family court was suffering from delays before the pandemic, and the pandemic has just made the backlog worse. Now, initially with the pandemic, a lot of family practitioners were actually quite excited by how quickly the family court adapted. Hearings went remote very quickly, so that meant that hearings took place by the telephone or some form of video platform. The court now have their own internet video platform that hearings take place by. And some hearings were still taking place face-to-face where justice required them to do so. We suddenly adapted to no longer using paper. All court bundles were suddenly electronic. So at first it seemed as though we may be getting rid of the backlog rather than creating a bigger one. But unfortunately, as time went on, there has been a lack of judiciary where a lot of judges have retired and they just haven't been replaced quickly enough. Courts having to be closed down where staff have caught COVID, restrictions on numbers in the office, which has just slowed everything increasingly down. They're now estimating that the backlog will not be cleared until 2023. And when they say the backlog will be cleared, what they're actually talking about is to get us back to a point of pre-pandemic backlog levels, not actually clearing the backlog altogether. Next slide, please. So the current position and problems, we've seen that there has been in the quarter from April to June, compared from this year to last, there has been a 14% increase in cases before the court. I don't think that that is really unexpected, because if you think back to that quarter last year, that was when we were all in our first lockdown and it was all very new to us. The furlough scheme was being introduced and people were really quite frightened about their jobs, housing and what was going to happen next. So in respect of my caseload, on my financial cases, I had a lot of clients that were just, let's just wait. I want to see what's going to happen. And equally, a lot of people were just simply not bringing proceedings because they needed to see how their finances were going to pan out in such an unusual situation. So we have seen in the same quarter that financial cases are up by 72%. And I don't think that that is unexpected because of what we faced last year. But the length of delays are now becoming really quite astronomical. It's being found that in some areas it's now taking 26 weeks to get to a first hearing, which means that a final hearing is some 2 years away. Private law cases, so this is children where there's a dispute about where they should live or which school they should go to, are now taking on average 41 weeks, and that's 13 weeks longer than this time last year. Delay is one thing, but what we've also found is that there are a lot of hearings now being adjourned at the last minute. So after people have waited months for a hearing, the day before they are told that the hearing won't go ahead because there is not a judge to hear the case. In some cases, this is happening on the morning of the hearing, which has a financial implication for the client because the case is ready to go, but equally it has an emotional and a psychological impact because they're then not told when the next hearing will be. And most people have really prepared themselves for that hearing with a view to trying to bring matters to a conclusion so they can move forward. So increasingly, people are wanting to know what the alternatives are. Next slide, please. So what we're going to be talking about is exploring the alternatives. Collectively, this is referred to as ADR, which is the alternate dispute resolution. And now people have got more options than ever for looking at their disputes without using the court. We're going to be talking about the advantages, how each of these systems work, and the benefits. So we're going to talk about collaborative law, mediation, arbitration, and private financial dispute resolution, so FDR, we like shortening everything. Next slide, please. Right, so bit of a funny picture there, isn't it? Whitewater rafting. It's not me and my family from last summer because we probably wouldn't have been allowed to anyway, but it's an analogy that we'll come into to try and understand how collaborative law works. So it originated in America and in Canada, and it is such an alternative approach to the traditional process. It's about reaching solutions amicably together by agreement. When we go through the court process, or even in solicitor negotiation, when a client instructs me, I work for them. I am looking for the best possible solution for them. When you do it in a collaborative way, we work as a team model. There are no opponents, we all work together. So the couple will each instruct their own collaborative lawyer, and all discussions take place face to face. And everybody has to commit that they are going to conclude matters without going to court. Now, that's a really big thing for a lawyer to say, because by signing the document, I am committing to the process. And if the process breaks down, I can't act for the client anymore, and neither can the other lawyer. They would have to instruct new solicitors to bring an application before the court. Now, I think that's actually something really good for clients because it is showing the commitment of the lawyers to the process and that they passionately believe that it can be useful, successful and beneficial to the family. So it is a holistic approach, and it's probably a hybrid somewhere between mediation and solicitor negotiation. So once both collaborative lawyers have been appointed, a first meeting will be booked. One of the benefits, this is at your convenience, not the court's. We all meet together, and this is where the whitewater rafting comes in. So we all have to agree we're going to paddle in the same direction, because if we don't, we're probably going to fall out and get wet. So there is going to be some difficult water as you go through the process. I'm not going to say that it's an easy process, but the reason why I am passionate about collaborative law is it's about putting you in the driving seat, prioritising what is important to you and your family, and finding a bespoke solution that works for you, rather than something being imposed, because do any of us really want a decision imposed upon us? It is a holistic approach, so where appropriate, a financial neutral can join the meeting, and that is somebody that will be there perhaps talking about budgets, talking about tax, talking about pensions. There could also be a family consultant. They're usually therapists in some way, shape or form. And if there are children involved or strong emotions that need to be managed, then that can be really beneficial in assisting people to move forward. Now, other than the participation agreement, before the first meeting, the couple are both asked to complete anchor statements. Now, I had a colleague a couple of years ago who her client got quite muddled as to what she needed to do, and she thought she had to write an anger statement. So it was quite cathartic, I think, for her client, but wasn't really what they were looking for the meeting. Now, the idea of the anchor statement is really what it says on the tin. It's about having a document that just brings us all back together, pulls us down, and helps us when the water gets rough. It's really about, why are we doing this process? Why have we chosen to do this rather than put ourselves at the mercy of the court? Where there are children, people usually have some sort of binding connection between the two of them. Quite often you will see on an anchor statement that actually, right now I'm finding it very difficult to communicate with you, but our son will get married one day and I want us both to be there, and for him not to have to feel that he can't invite both of us. They're the things that bind couples and assist them in being able to go through the process. It's actually incredibly beneficial, because what a message does it give to your children that despite whatever has gone on in your relationship, you are working together to find a solution that is best for your family. That really sends a strong and positive message to those children. It's really useful having meetings face to face. Sometimes cases can get lost in paper, lots of letters going backwards and forwards. When discussions are face to face, it's less likely that there's going to be a miscommunication or misunderstanding, because everybody's there to ensure that everybody understands and is on the same page. We have had clients report that their communication is improved after the process, enabling them to move forward with the next chapter of their lives. I like it because I like out-the-box thinking in a way that the court probably wouldn't, but actually works for a particular family with their financial arrangements. Birkett Long has got the largest collaborative team in Essex, and that is a mixture of both male and female lawyers. Next slide, please. So we're going to talk about mediation next. So mediation, the role of a mediator is one of an independent and impartial person. They're trained as mediators. Quite often they are also family solicitors, which is useful because they understand the process. And their job is to facilitate the discussion and provide information to the couple. They're not there to advise either one of them. So quite often clients will have solicitors in the background to assist them in filling in those legal gaps. Now, it works by, initially, clients will attend a mediation, information and assessment meeting, often referred to as a MIAM. This is something the government brought in a few years ago because they didn't want people just issuing applications to the court, and they wanted to divert people away from the process wherever possible. There are obviously exemptions, so sometimes people can still rush off to court and make applications where it is necessary to do so. But on the whole, clients have to attend one of these meetings first. They take 30 to 45 minutes, and in that time the mediator will discuss what's going on with you, whether or not, how the mediation process works, and whether or not it might actually be suitable for your family. At the end of the process, the mediator will confirm whether or not they think that you are suitable. If you are suitable, then there are two options. One, your other half is then invited to go through the same process with a view of a joint meeting then being booked. Or alternatively, if at the end of the meeting you feel that you still wish to make an application to the court, they will then sign the relevant form, which will enable you to do so. There are lots of different types of mediation. For the last 18 months, like many aspects of our lives, have been online. But increasingly people are going back into offices. You can have shuttle mediation, where the mediator moves between rooms, shuttles between, so that you don't have to be in the room with your ex-spouse. There can be lawyer-assisted mediation, so you feel a bit more supported in the process, and also direct child consultation. A recent report suggests that 70% of mediations are successful, and the government are so committed to trying to divert people from the court process They have allocated £1 million worth of vouchers. Couples that are going through mediation with an element of children matters can obtain a voucher for £500 towards the mediation costs. There are a lot of mediators in this local area who are signed up to the scheme. So if it's something that you'd like to know more about, please just drop me an email and I can give you some more information and signpost you to those that are running the scheme. It's seen as it can also be beneficial from a cost perspective, but equally from a communication perspective, because it's not for the mediator to tell the couple what to do, but to assist them in finding what is the right solution for them. It's not for everybody, but for those that it's suitable for, it can be a useful tool. Next slide, please. Arbitration. So this is relatively new in England, particularly in family work. Increasingly more people are being trained to be arbitrators. These are solicitors, barristers, retired judges, and it gives real flexibility in a case. Now, arbitration can be used for a whole case, or it can be used for discrete issues. The majority of cases that I have come across that have used arbitration are for discrete issues, and it may be that the parties have been able to resolve everything barring one particular issue and they just cannot agree. So what happens is, between the parties, they decide who is going to make the decision, who is going to be the arbitrator, and they are appointed. They get a copy of all of the papers, they read them all. If it's a discrete issue, they may give a decision on paper. If it is looking at all assets and an overview, then they may have a face-to-face, almost like a hearing with the parties. Now, what's interesting and what is different about arbitration is the decision is binding. That's different to mediation, because even if an agreement is reached in mediation, until that is converted by a solicitor into a court order and has been approved by the court, then the decision is not binding. With arbitration, it becomes binding once that decision has been given. So it can be flexible, it can happen really rather quickly, but probably one of the biggest selling points of arbitration is it's being kept out of the public eye. It's done very privately, and it has therefore been of great interest to those that perhaps would want to keep their private lives exactly that. Next slide, please. Right, FDRs. Now, FDR stands for Financial Dispute Resolution. When a financial application is made to the court, there are 3 potential hearings, and this is the second stage hearing. The second stage hearing is really a negotiation hearing. A judge reads all of the papers and then is there to assist the parties in trying to reach an agreement on the day. Because you get an input from a judge saying this is what they think is fair, and if the case went to a final hearing, that's what they think the outcome should be. But increasingly, where we have been facing so many delays in the court process, increasingly barristers' chambers are offering the services of private FDRs so that clients are able to book them at their convenience. They get to select who is going to make the decision on their behalf. They aren't competing with other cases because you have booked that person's time to read your papers and to assist you in reaching an agreement. It's been deemed to be a little bit less adversarial, because rather than being rushed, people have got more time to negotiate, and they can ask for the input as and when they need it, rather than potentially on the day of the hearing being told that no judge is available. It puts clients in the driving seat of how quickly these things are managed. You aren't bound by the indication, but it is an indication of what may happen at a final hearing, and it can be a lot quicker than the court process once there has been full financial disclosure. A lot of people have said that they feel that there's a better chance of settling because people are taking control of the process and saying, I don't want to wait for the court process in which I may not have a hearing, or a hearing may be delayed or adjourned at the last minute. So actually, this is the person we're going to see. This is the date we're going to do it. Let's see how much further forward we can get. Next slide, please. So in summary, there's now more options than ever to place clients in the driving seat to try and reach a resolution that doesn't mean that they have to go to court. Now, the court is always going to have a role, a very important role, but it should be the preserve of cases that need a judge to be involved and should be seen as an option of last resort. Next slide, please. Sorry, my piece of paper was in the wrong way around. So we're just going to have a quick roundup before I answer any questions. So before we take questions, we will be sending a recording round to everybody who signed up to this webinar tomorrow morning. We'll also be including a link to a short survey. Please could you complete it, because it's really helpful for us to know what you may want to hear about in the future. As I said at the start, this is one of a series of webinars that's being held. The next one is on Wednesday, the 20th of October, which is about a construction law update. So if you're interested in our future webinars, please visit our website or our Eventbrite page to sign up. I guess please let me know what the questions are.
Thank you, Fran. We have had a few. So the first one is, are remote hearings as effective as those that take place in court?
Well, that's a really interesting question, because there has been quite a lot of controversy about the remote hearings and whether or not they are fair. Particularly in public law cases, that's where the local authority may look to remove a child. They have been seen to be unfair because parents may not have the equipment that they need to be able to participate in those hearings properly. But another example is directions hearings taking place over the telephone, where the court is really just putting in place a timetable of what needs to happen next. And that's really effective and makes the court much more efficient. So it's a difficult question to answer, but I suppose it's a bit of a politician's answer, I'm afraid, which is that for some hearings, yes, much more efficient. Some, unfortunately, no. And that's why the court have been very keen and have been having cases face to face where it's necessary to do so. I hope that's okay as an answer. But if anybody wants to know more, just email me.
Don't turn into a politician on us, Fran, please. Next question is, how long does a collaborative case take?
Oh, it really depends. We go at the pace of the person that is sort of slowest. I'm not sure that's the best term, but what we tend to find is when a couple separate, emotionally one person is usually further ahead than the other person, and that's usually the person that has decided to separate. Emotionally they're further ahead, so we will have meetings at the pace of the slowest person, but on average I would say 8 to 12 weeks. I have had one case that settled in 6 weeks, and that was with 2 meetings. The other one was 4 meetings, because that was the pace that we needed to go at, but it is a much quicker process.
Great, thank you. Next question. My child, who is 13, is currently angry with her dad as he's been having an affair with her friend's mum. She's refusing to see him. I have tried to get her to see him, but she will not. I do not want to go to court. What would you suggest?
That's a really difficult age, and your daughter is clearly looking to protect you as well, and you're trying to be a good parent by ensuring that she sees him, but it sounds like emotions are running quite high at the moment. What I would suggest is actually looking at mediators who offer direct child consultation, because then your daughter can actually have an input and express her emotions and her upset as to what she may want moving forward. And that may be a way to explain to her dad how she's feeling and why, and to assist in trying to get the relationship back on track. But a difficult one, but that would be my first point of call.
Thank you. Is a private FDR, so it's a financial dispute resolution, is a private FDR binding?
Unfortunately, it is not binding. Like the court process, it is an indication to assist parties in coming to a conclusion. If an agreement is reached, it can be incorporated into a consent order, which then becomes legally binding. But the actual decision and indication in and of itself is not binding. So that's where it differs from arbitration, which would be.
Okay, thank you, Fran. That's all the questions we've had.
Well, I'd like to say thank you very much for joining us today. These are my details, so if I can assist any further, please do get in touch with me. I would like to help you if I can. Thank you very much for attending.